It basically means that it can be shared by SARS, provided that all the boxes have been ticked. Now, the box in which you are referring to is the balancing act between your right to privacy as per Section 14 of the Constitution and the right to access to information as per Section 32 of our Constitution. And the most important thing which was mentioned by our courts was to say that if it is in the public interest that such information ought to be disclosed, then definitely it must be disclosed by SARS. SARS can no longer hide by the confidentiality clause and say we're not going to disclose anything. I think the most people are going to be most affected by this is our politicians, in which they can no longer say we are not going to disclose our tax affairs. It's going to be something which is going to be out there in the open, provided that the procedures in terms of those applications that must be done and the showing the need of public interest that exists has been displayed by those who are requesting information. So members of the media are now going to have access to various tax records in which our politicians are then submitting on a yearly basis.
But one would also question then, Mpumelelo, what does this say about someone's privacy, confidentiality? It seems as if this ruling says that the public interest then outweighs, your right to privacy and your right to confidentiality.
All of our rights in terms of other than the right to life are not absolute, meaning that they can be shrinked or some of those privileges can be taken away provided it's in the best interest of the public, that those particular rights can then be taken away or part of it can then be removed from us. Now, Section 36 of our Constitution deals with exactly that. It says, how can we apply less restrictive means in terms of protecting those particular rights while being able to satisfy everyone who is an interested party in this matter? So we have to look at it from this instance. Why should the tax records of a public figure be hidden when that particular public figure has put themselves out as a person who is for the people and by the people and is working in the interests of the individuals and members of South Africa? So if you are clear in terms of saying, I want to abide by the law so much, I want to make sure that I lead by example, why should the public or tax records be hidden? Obviously, it's not going to be a free-for-all type of situation where anyone can apply and be able to get those records. However, it's simply saying, open up an opportunity in which if members of the media are asking for those reports, the sole intention being that it's in the public interest that such be known, then allow them to have access to those reports so that they can be distributed. You can add other provisions or conditions as to how those particular reports ought to be released. There's certain things which are not going to be included in those media briefing or the newspapers or even TV screens in which you are going to read and see. However, open up the window in which they are then able to have access to those records. It can't be that they are going to be hidden all the time and they are going to be things in which they are going to be sacrosanct. Also, take into account this particular matter. Remember that the person who was at the heart of this application has said a long time ago that I don't have a problem with my reports being released, but it was SARS which was insisting and saying that we have a confidentiality clause that you have to stick to. So on that basis, we're not going to release those reports. So Parliament has 2 years to come up with the modalities of saying, if the instances or an application such as this one has been made, what is it that you must look for, Mr. Commissioner? Under what circumstances are you then going to deny that particular request? And if everything fails, let's go back to court. And the definition of a public interest will then be dealt with in line or tailor-made to the facts of the case that would have been made, that would have made up that particular court application.
And when you look at the issue you've just mentioned, which is SARS, previously saying that it is bound by a confidentiality clause, what does SARS need to do immediately now?
They need to go back to the drawing table and say, under what circumstances are we going to release this type of information? Let's start with the application form. What sort of information are we looking for? And if we are releasing the information pertaining to the one tax affairs, what exactly are we looking for? Is the annual tax return? Is it whether confirmation that an investigation has been done? Are we looking at the intimate details of our investigations that we would have conducted at SARS? Are we looking at the amounts in which maybe we would have paid to them or they have paid to us? The instance or the manner in which we do our investigations as SARS. So it's all those factors that needs to be considered by SARS as of tomorrow morning, so that they're able to deal with the influx of information, requests for information which are going to come in. Now, it's not something new that they would be doing. Remember that in terms of PIA, there is some sort of a process. There is an information officer that is there. All that he or she has to do is to go back to the drawing table and say, in an instance in which they are looking for the particular tax records of a taxpayer. What is it that you have to do? In instances where we have not received consent from the taxpayer, what are the type of instances, or what does the law allow and what does the law doesn't allow? In an instance where consent has been granted to us, then kudos to us. We can release those reports without any qualms, because they would have said on their own, you can go ahead. But if we are going to release reports that are going to jeopardize our investigations, jeopardize the manner in which we do our job on a daily basis, then they may have a point in refusing information being released. But other than that, they have to comply with what the court has stated.
And Mpumelelo, while SARS undergoes this process as well as Parliament, what does it say then about those media houses that actually asked for the access? How soon can they access that information?
I think that it can be accessed within, let's say, in the next 30 days, depending on what SARS is actually saying. The only thing in which I was worried about, I get very worried if the judges or the presiding officers are going to read into their order how the legislation ought to be drafted. The judges are not there to draft legislation, they are there to interpret the legislation, because you must then cater for instances in which I, as a member of the public, would want to challenge that particular part that has been written by a judge. Now, it makes quite a peculiar situation if I then go back to the same constitutional court and try and dispute the constitutional validity of something that they have written themselves, which is why there must be a clear separation of powers between the presiding officers, who are simply there to interpret the law, and the legislatures, who are simply there to make sure that they're able to draft the laws and be able to put it in a manner in which it is complied with our constitution. But the immediate effect of that is that as of tomorrow, make sure that you have a process that will allow members of the public, including members of the media, to have access to those reports. If you can't, especially if consent has not been granted, then find ways in which you are trying to balance the two. But there are a number of other institutions that battle with this type of thing on a daily basis. For example, banks. Well, you can maybe pop over to them and check, how do you guys do it? When do you report? When do you not report? In what instances are you then forced to go to court in order to protect the confidentiality of your clients? And then let's take it from there.
And you mentioned earlier that former President Jacob Zuma was at the center of this court matter. What do you say to those who say, well, there again, former President Jacob Zuma is being targeted, he is being victimized, and he will be victimized through, this ruling from the Constitutional Court?
I think depending on what exactly they find and the way in which they would want to interpret it, I think anything that is there can change, unless if the former president would say the information which has been provided by SARS is incorrect. On that basis, then he might be forced to litigate. But if everything that has been stated is actually true, then you've got nothing to hide. Also, let's remember, if you portray yourself as a public figure, it means that the level of scrutiny is not in the same level as any person on the street. You have put yourself out there as a person who's upright, as a person who's fully complied with the law and is beyond approach in terms of complying with any legislative privileges which are applicable to South Africa. Then you must be able to live by example in any instances in which your standpoint or the manner in which you carry yourself is being tested, including the manner of assessing whether you've been submitting your tax returns. Allow yourself to be subjected to that and be able to respond accordingly. In instances where you have not complied, come back and say, yes, I haven't complied. In instances where the information is incorrect, provide that corrective measure and say, these people are not telling the truth. This is how things have taken place at the end of the day. But it's high time in which we must hold our public members are accountable. And the only way in which we're going to be able to do that if we have access to information which is pertinent to them.